Hi, my name is Francie Schaefer, and I'm going to be doing my presentation on the reality of mental health law. First, we're going to be looking at what exactly mental health law is. Mental health law includes a variety of legal topics surrounding the mental health of the individuals involved in the court. Some examples of these are competency, which signifies a legal conclusion that an individual is capable of entering into a binding contract, transferring assets, or participating in a legal proceeding. Legal standards, which surround the process by which those who are mentally ill can be forced, against their will, to receive treatment. Involuntary commitment is an example of these legal standards, and this severely infringes on a person's right to be free from governmental restraint and the right to not be confined unnecessarily. The courts have held that competency in legal standards must bear some reasonable relation to the purpose for which the individual is committed, so there's a lot that goes into determining the mental status of a person, as far as whether or not they're competent to stand trial or as far as they need to be committed to involuntary treatment. Other examples of mental health law include insanity defenses and trial and treatment of the mentally ill. Usually, states dictate how and when the insanity defense may be invoked in state court, while on the other hand, the federal government does so for the federal court system. In 1984, the Insanity Defense Reform Act was passed, and this placed the burden of proving insanity on the defendant, and it cut the use of mental illness as a defense. There are many different laws that allow discrepancies in the level of benefits for individuals with mental illnesses, and these include parity, minimum mandated mental benefit, and mandated offering laws. For one, parity is the most beneficial as it requires that there are no differences in the level of benefits for those with mental illnesses, so companies can't discriminate based off of this level of severity for a person's mental illness. Minimum mandated mental health benefit allows for some discrepancies in this, whereas the mandated offering law does not require that benefits are provided at all. They can have coverage as an option, but it can be accepted or rejected based off the company. Although there are different mental health laws, the World Health Organization lists 10 basic principles that they deem necessary. Number 1 is the promotion of mental health and prevention of mental disorders. Number 2, access to basic mental health care. Number 3, mental health assessments in accordance with internationally accepted principles. Number 4, provision of the least restrictive type of mental health care, which explains that persons with mental health disorders should be provided with health care that is the least restrictive upon them. Number 5, self-determination, which explains that consent should be required before any type of interference with the person can occur. Number 6, which goes along with the last principle, which is the right to be assisted in the exercise of self-determination, which basically explains that a person can be assisted by someone else in case they have difficulty understanding certain decisions because of their mental illness. Number 7, availability of review procedure, which basically means that if there was a decision made by either a judge or a representative or a family member for a mentally ill person, there will always be this availability to have that decision be reviewed at any time. Number 8, which kind of is an extension of the last principle, and that's automatic periodical review mechanism. So the last principle says that there's an availability of this review procedure, but the 8th principle explains that if a mentally ill person was confined to either involuntary commitment or anything that would have a lifelong impact of them, then they automatically have to be reviewed again. Whereas the last principle is basically explaining that there's an availability of this. The 8th principle ensures that for decisions made that could be affecting the person lifelong, they will always have a review in place to see if that decision has to be long-standing or not. The 9th principle is a qualified decision maker, and this explains that someone has to be qualified to make a decision for a mentally ill person, so they must be competent, knowledgeable, and impartial. So this relates to anyone, whether it's someone as low as a relative or a friend of this person or as high as a judge. The last principle is respect of the rule of law, and this makes all of these principles applicable to anywhere in the world because in different countries there are different laws and legal proceedings in the court system, so this ensures that any decision made for a mentally ill person follows the rules of that country or government. Even though there are these principles set in stone for mental health law, the reality of mental health law that is going to be the focal point of this presentation is that there are more negative than positive aspects of mental health law. So, what is surprising to me that may be surprising to everyone else is that law plays actually a very prominent role in psychiatry than it does in any other field of medicine, and this is because of the tragic things that are surrounded with mental health law. One of the biggest issues at hand that we talked about previously was involuntary commitment, and another thing is that the laws about mental health are actually very outdated. Many people are probably familiar with HIPAA, and this protects the medical information of individuals and limits the information that doctors can share with the patient's family. So, overall, this might seem like a positive thing for any other field of medicine, but for psychiatry specifically, HIPAA can kind of hinder on the treatment of those mentally ill people. For example, say that an individual were to visit some hospital for the very first time because they're having a mental breakdown or a mental crisis, and they tell the doctors that it's their first time, it's nothing serious, nothing to worry about, so the doctors don't really think much of it and they just send them home without any other treatment. But later they could find out that this person actually does have a history of mental illness and they could have potentially sent this person away without realizing this because they weren't able to contact the family members due to the protection of HIPAA. So first we're going to be looking at some facts and I'm going to be giving you some numbers about mental health that may or may not be surprising to you. Schizophrenia and bipolar disorder are two of the big disorders that kind of come into play when thinking about mental health law because of the severity of them. And overall, there are 8.3 million adults that are living with either one of these disorders. The National Institute of Mental Health estimates that there are 5.5 million people with severe bipolar disorder, and of these 5.5 million people, 51% of them are untreated. And there are 2.8 million people living with schizophrenia, and of the 2.8 million, 40% of these individuals are untreated. Unfortunately, there are many negative consequences of these individuals with serious mental illnesses that are going untreated. In a report from the 2015 Annual Homelessness Assessment, they report that there are 169,000 homeless people with serious mental illness, 383,000 inmates with mental illnesses in jails or prisons. 50% is the estimated percentage of individuals with schizophrenia or bipolar disorder who attempt suicide at one point during their lifetimes. An estimated 10% of homicides involving an offender with a serious mental illness. An estimated 29% of family homicides are associated with a serious mental illness, and an estimated 50% of mass killings are associated with individuals with a serious mental illness. One of the key reasons why a lot of individuals go untreated that are living with a serious mental illness is because they lack insight into the condition or the serious mental illness that they have, and this is known as anosognosia. Anosognosia is a symptom of severe mental illness that is experienced by some individuals, and this impairs a person's ability to basically understand and perceive whatever mental illness that they have. This is the single largest reason why people with schizophrenia and bipolar disorder specifically refuse medications or do not seek treatment, simply because they have rationalized this idea that if they don't understand or know that they have a mental illness, then it's rational for them to refuse treatment or medication. Although this is said to be a symptom of individuals with severe mental illnesses, there is evidence that shows that there is anatomical damage in the part of the brain that is involved with self-reflection. So, some staggering numbers is that 50% of individuals with schizophrenia and 40% of individuals with bipolar disorder experience this symptom, so it's likely that they have damage to this part of their brain. Fortunately, taking medication for these individuals does improve insight in some patients, but not all. One of the negative aspects of untreated individuals is that they are at a higher risk for a number of negative circumstances that can severely impact not just them, but everyone around them. These negative circumstances include homelessness, psychiatric boarding, which is basically when people are in a mental health crisis. They often have to wait for days or even weeks in the ER or the hospital to wait for a psychiatric bed because of the shortage of them, and we'll be talking about that later in the presentation. Other circumstances include arrest, incarceration, victimization, suicidality, family violence, and being a danger to others. So, as you can see, the human, social, and economic impact of not treating people with serious mental illnesses is beyond calculation. Next, we're going to be looking at some more negative aspects of mental health law, which includes criminalization of mental illness, public service costs, psychiatric bed shortages, and violence. For the criminalization of mental illness, there have been 50 years of failed mental health policy, which has led to law enforcement being on the front lines of mental illness crisis response and in turn turned jails and prisons into basically asylums for these individuals with mental illnesses. Deinstitutionalization, outdated treatment laws, which previously would basically demand that a person has to become violent before any sort of intervention happens. Discriminatory federal Medicaid funding practices, which relates back to the mental health laws that were talked about prior, about how people can discriminate on individuals based on the severity of their mental illness or basically what they're willing to fund and give treatment for, as well as the failure of states to fund their mental health system, and the failure of this funding ends up driving those that are in need of care and treatment from a psychiatric facility into the criminal justice correction system rather than into the public health system or into some sort of treatment, which is where they belong. There are, of course, many consequences of the criminalization of mental illness. So, for one, in 44 states, a jail or prison holds more mentally ill individuals than the largest remaining state psychiatric hospital, which is pretty staggering. In addition to this, individuals with psychiatric diseases such as schizophrenia and bipolar disorder are 10 times more likely to be in a jail or prison than a hospital bed, just because of what we were talking about, the failure to fund the mental health system leads to these people being diverted into jails and prisons rather than getting the treatment that they need. The criminalization also worsens the health of hundreds of thousands of people, burdens law enforcement and correctional systems, and it costs taxpayers countless number of dollars. Fortunately, some states try to divert people from jail or prison if their crimes are known to be a product of their mental illness and not because they just simply committed the crime. But this diversion does not really do much to fix the overall mental health system. It's just contributing to the added kind of pushing people away with mental illnesses and not really dealing with them, whereas people should be focusing on fixing the mental health system in order to make sure that they don't end up in jail or prison in the first place. Another negative aspect of mental health law is the public service cost, which was just mentioned on the last slide, because the sickest citizens who aren't able to get care frequently end up in a system that's not really designed for frontline mental health care. So often the group of people repeatedly just cycles through courts, jails, hospital emergency rooms, homeless shelters, and the cycle never really stops because they aren't getting the adequate health care that they need. As I mentioned previously, individuals with diseases like schizophrenia and bipolar disorder are 10 times more likely to be in a jail or prison than a hospital bed, but these individuals with these diseases are not the only ones that are dealing with this constant cycle in the inefficiencies in care. One of the key issues that goes along with this cycle for the inefficiency in care has to do with mentally ill patients in the ER and hospitals. And ERs typically hold mentally ill patients for such an extended period of time. And one study had found that 70% of ER administrators held mentally ill patients for 24 hours or longer, simply just waiting for a psychiatric bed. In addition to this, police and fire responders are often diverted to mental health crisis calls. And in 2017, there was $918 million spent by law enforcement on transporting people with severe mental illnesses. One of the main reasons that's led to basically all of these negative aspects of mental health law is psychiatric bed shortages. Psychiatric hospitalization is usually the treatment option of last resort for individuals with acute or chronic serious mental illnesses who need intensive inpatient care. Surprisingly, the number of state hospital beds in the United States has plummeted almost 97% by 2016, and the number of beds per 100,000 people in the U.S. ranks the nation at 29th among the 34 countries in the Organization for Economic Cooperation and Development. And in addition to this, by 2014, 10 times more people with serious mental illnesses were found to be in prisons and jails rather than in state mental hospitals, which this is widely attributed to the shortage of psychiatric beds, and this should be enough for people to realize that the mental health system really needs reformation. A common misunderstanding about people with serious mental illnesses is that they're very dangerous to themselves and the community, but this is not the case. Actually, most acts of violence are committed by individuals who are not mentally ill, and people with mental illnesses are actually more likely to be victims rather than perpetrators of such violent acts and crimes. On the other hand, it is true that violence is more common in individuals with serious mental illnesses that have either psychosis, paranoia, or hallucinations present, and this is commonly associated with schizophrenia. The National Institute of Mental Health does report that people with serious mental illnesses are 3 times more likely to be violent than the general population, and of course, when either substance abuse, a previous history of violence, or refusing to take medication is involved with this, the risk becomes even higher. But suicide is actually the most common form of violence that is associated with serious mental illnesses. Fortunately, involuntary treatment has been found to reduce the risk of suicide and violence along with many other consequences, but as you learn, there are not enough individuals that are actually getting this treatment, and rather they're ending up in jails or prisons or on the streets. So now you might be wondering what exactly is being done to fix the US mental health system. For one, the promotion of assisted outpatient treatment has included individualized plans such as case management, personal therapy, medication, and other tools that are known to promote recovery, and these laws have been shown to actually reduce hospitalization, arrest, incarceration, homelessness, victimization, and prevent violent acts that are associated with serious mental illnesses. In addition to this, there has been an improvement in civil commitment laws and standards, as well as restoring psychiatric beds and rethinking mental health policy. The Treatment Advocacy Center is where I did a lot of the research for this topic, and since its foundation, over 30 states have reformed civil commitment laws and standards. In addition to the Treatment Advocacy Center, the Bazelon Center for Mental Health Law is also advocating for mental health law in various ways. One of the key issues that they focus on advocating for is education. On their website, they advocate and promote many different ways that individuals can be ensured that they have access to mental health services that can help them live and work in a community with their mental illness. They also played a major role during the mental disability rights movement in the mid 1970s and were involved in a lot of court decisions that finally reformed the mental health systems and set standard practices in the mental health system. While the mental health system is still being fixed, the best thing that we can do is to end mental health stigma in order to advocate for better policies and treatment of those with mental illnesses. Thank you for listening to and watching my presentation. I hope you guys enjoyed learning about mental health law.